passed by the division bench of the Calcutta High Court, before whom the judgment dated 12th May 2023,
Yes.
passed by the next single bench in WPA number 21187 of 2022 was under challenge. The petitioners have raised a grievance before the division bench of the High Court of Calcutta that they were not a party before the Red Court, and the entire selection process to the post of assistant teachers.
Yes,
Primary assistant teacher.
Assistant teacher within bracket untrained.
No. Assistant teacher. No, primary school.
Primary, but we were in the untrained category. You're not
untrained. We are trained now.
We are trained. Now we are trained.
Only untrained.
Yes,
We are not asking.
There are different.
This selection was with respect to
assistant teacher. Yes. No dispute.
Assistant teacher.
California. In matter challenging the matter of selection to the post of assistant teacher in bracket untrained. Full stop. However, the direction as issued by the single judge is in gross violation of the principle of natural justice without joining the affected person as a party to the proceeding and affording them an opportunity. Full stop. The division bench of the High Court of Calcutta has considered this said aspect, and by granting the interim relief, page 22, at page 22, the court observed the court has granted the stay on the termination of the appellants, but also observed as thus. You please page 22, A to A. Full stop. The court
Yes, sir. Matter shall be for appropriate way.
bring the opposite. Court said the matter shall be placed before the appropriate division bench in the first week of September. Full stop. The primary contention which was advanced before this court is that the petitioners were not a party before the Red Court. However, their selection cannot be set at naught with a further direction to hold a fresh selection in a time-bound manner. This also urged that when the division bench, by considering the interim prayer as a state, so far state the order into so far as it relates to termination is concerned, because they were not party, then the other direction to hold a best process of selection, terminating the services of the affected person, is not proper. Therefore, staying the said part of the order, the parties may be relegated to before the division bench to raise all the contentions grounds which may be directed to be adjudicated in a time-bound manner, looking to the nature of the controversy as involved both the court as well as both the appellate court. And a council representing the writ petitioners and the state writ petitioners. Council appearing on behalf of the board. Learned Senior Counsel Gupta appearing on behalf of the board. The students that the selection was of how many people? 32,000.
32,000. Plus sometimes the learned judge is saying 36, sometimes he is saying 32. What is the basis?
Approximately 35,000.
Approximately 35,000.
32.
Approximately of 32,000 assistant teachers.
What is the basis?
Somewhere it is 36. So he has changed that order. He has changed.
Subsequently order correct.
Let me take it.
Change it out.
You see, you will find the answer of it. Appears to be more than 30,000 assistant teachers in the country. However, to call them and to hold a press interview within the time frame is not possible. In addition, it is a expensive exercise which cannot be possibly done. Full stop. On the other hand, the council appearing on behalf of the writ petitioners contains defended the orders of learned single judge and contains that once the process of selection is found at fault and the interim relief regarding termination of the services of petitioners have been directed by the writ court, interference may not be warranted in this case. After having heard and counsel for the parties, without expressing any opinion on the merits of the facts and the legal position as brought over notice, we are impressed upon only one submission that the order passed by the next signatures is without joining the petitioners,
Even in a representative capacity.
joining the petitioners as a party or even in a representative capacity in the proceedings. Full stop. We are further impressed that once the said contention was found merit before the appellate court while granting the partial interim relief, at that stage, issuance of the direction for
Holding press selection.
conducting the selection as directed by learned single judge is not justified. Full stop. Therefore, therefore, we set aside the interim order to the extent of issuance of the direction to conduct the selection afresh as directed by learned single judge. Full stop. The said order is subject to final outcome of the orders of the writ appeal, orders in the writ appeal. Full stop. We have, as we have already on the cost of repetition, it is made clear here that we have already expressed that we have not considered the merits of the contentions of any of the parties. However, we are at liberty to raise all those contentions before the appellate court, which shall be duly
On its own merits.
considered on its own merit.
Including the natural justice. You can raise that it is not required. It is a huge fraud. Impossible to raise all that.
All contentions before the appellate court. First of all, considering the fact that it's a matter relating to selection and appointment of the last number of the assistant teachers, we hope and trust that such controversy ought to be decided with an earliest. Therefore, we request the High Court to expedite the writ appeal. As expeditiously as possible.
And accept notice, otherwise we will be committing.
Sorry, the so and so accept notice on behalf of the writ petitioners on the top. Okay, then by consent of the parties, the case is heard.
Item 58, permission to file SLP may be granted. Yeah, item 58.
Why you are not in the writ appeal?
We were not in the rate appeal, but our services were terminated, so we have come here.
Permission.
56, 57.
Permission.
No. It's only a permission case.
Permission.
No, not 56, not permission.
11.1 and 2 say.
Permission.
Permission. 57.1.
You are doing a hop step and jump.
Just very clear, very clear. 57 and 1 and 2 and 58. 7.1. Only one. In any other case in which permission issues there? No.
Not for all.
Right. In other cases, anything want to say?
No.
Very comprehensively.
Very
technically worded.
I have patient.
Very well.
Please change the nomenclature. Doesn't sound good. Untrained teacher.
No, exactly, Milord, I wanted to do that.
Please change.
No, exactly, I wanted, Milord, just a minute. That was earlier the provision was that, Milord, that untrained can be file an application. The provision Act has been amended and it has been said by 2019 all have to be trained and all we are trained. Therefore, I wanted to say, don't say now untrained now I am. I am not untrained now. I am trained.
No, my lord.
What does the rule say?
What untrained is being used is only with respect to that selection process.
Exactly. Not for any other.
Only to contrast between those who undergone.
These were the exemptees under 23 of the NCTE Act.
Yeah.
Your Lordship remembers that 5-year period, initial 3, then 5. So this was that exemptee under that exemption period.
People who came on the bench.
Lordship, if I may just submit withdrew the exemption.
Employees as well as board are disposed of.
Effectively, what has happened is before 2009, there is no so much colleges in all over the India. There's a relaxation has been made up to 31st March 2009.
Lordship, in fact, the original vacancy did not differentiate between untrained and trained. The Act required first to whoever passes the TET examination and trained, give them appointment, then whatever is left out to be given to untrained. That's as per the scheme. So the recruitment process is a same.
Mr. Kunal, I was only saying you may call them exempted teachers, you may call them.
That's what the
Statutorily exempt.
Untrained part of it.
Lordship, I have filed can I put in another word? You are fighting for teachers, employees, alike. Those are for education. Think one point. Now this education has come down to literacy.
Education has come down.
Lordship,
Literacy. And therefore all this teacher, Guruji, all this. Think of it. This is
This, what Mr. Chatterjee was telling,
Now on the battery is over.
amended.
Battery is over. You
That
got
was amended in
Now, may I submit one thing? This is a thing. Not your lordship appreciate not inter thing is not under scanner.
similar SNP